Welcome back, everybody. Welcome back to the Capital Contribution Live. I'm your host, Yuri, owner and operator of Ovich & Associates, the fun CPA, bringing you value in every single step of the way, every single process. The Capital Contribution Live is all about teaching you the things you should have learned in high school. And one of the things that I've found that during the real estate process, the closing process that I've had on the purchase of my home, I was confused. There was a lot of moving parts, very stressful. And I decided, let me add value to the listeners based on my own experience. And that is why I launched this. This is season 1. This is episode 2 now. We're talking about the attorney side of things, real estate law side of things. And today on the show, I got Andrew Bershtein with me. Did I say that right?
You're perfect. Andrew Bershtein. Happy to be here, Yuri.
Yes, awesome. And it is a pleasure to have you on the show. Interestingly enough, I knew you since the days at Rutgers, man.
Yeah, long time, bro.
Long time ago.
It's been a minute.
What we got together? We had that little dancing, right? The
ballroom dancing.
Ballroom dancing.
Maybe a little drinking on the side.
A little drinking on the side, yeah. But you know,
fun.
It's a small world, and I'm really, really excited. Like when we reconnected a while back, I was like, this is so cool to just come on back full circle. I was part of the transaction. You were guiding the other side. In our transaction on the buyer side of my house, but it was just great, and it's awesome to reconnect. It's awesome now to have you on the show, bring this full circle really, and have you bring your knowledge to the listeners. So introduce yourself, tell everybody your firm and everything, and kick it off.
Absolutely. So Andrew Bershtein, I'm the owner of BershLaw Law. We are a full-service law firm, meaning we do work in various fields. My personal practice is 95% real estate. That is what I'm focused in and what we specialize in on my side of things. But we do have other attorneys who specialize in things, tax law, trust and estates, litigation. So we have a lot of attorneys who work with us. We're very fortunate in that way.
Awesome.
And as we kind of discussed, so you and I know each other for forever.
Yeah.
But most recently we came across each other. I was representing the buyer of your house.
That's right. You were.
And you were working.
It was very smooth.
Another very talented attorney. So
Yes.
we were fortunate to have a smooth transaction, I believe, at least from our side.
Yeah, it was great.
And it was great to reconnect. It was great to touch base. I'll take a moment to mention, this may be considered attorney advertising, so anything that I say, please take it with a grain of salt. And B, anything I say today is not legal advice. Please do not rely on it. Please do not consider me your attorney unless you call me and we have a nice conversation. I'm happy to be an attorney for anybody out there.
Fantastic.
We are here and available. If you're looking for us, we're at www.BershLaw.com, BershLaw.com, or my personal cell phone. Anybody wants to reach out, 908-217-7022, and we're here and available for you.
Awesome. And that's great. That's a great segue as well. And also, we're going to have in the show notes of this episode in the YouTube in the show notes, going to have all the information as well. But that's great. Giving out your cell phone, man. I love it.
I give my cell phone to everybody.
I love
That's
it.
actually
I
a policy. So one of the things that generally happens in real estate is people work in volume practices. And I'm sure we're going to get into this in a minute.
Oh, yeah.
One of the hardest things to do is to nail people down.
Yeah.
And in an industry that specializes in making it hard to find people, we'd make it a point for everyone to know exactly how to reach us.
Yeah.
And that's one of the things that we really pride ourselves on at our firm.
I love that. Well, that's great, and so that leads me into the segue. Let's get started like real high level, right? So you are a practicing attorney. So you went to law school.
Yes, sir.
Now, how did you get into real estate, right? Part of it, and tell me what it takes to become a lawyer and then to focus on real estate like you did.
Absolutely. So specifically as to real estate, my father was a general contractor in Staten Island. From the time I was about 13 years old, I was going up and down the ladder doing whatever needed to be done.
Awesome.
I like to joke around that I've poured foundation, I've done roofing, and I've done everything in the middle. And it's
great.
kind of, at this point in my blood, it's been part of my life for a very long time.
That's awesome.
As to specifically real estate in New Jersey, I had a partner in New York City where I was working as an attorney. I'll get into how we got there in a second.
Yep.
He and I parted ways. I live in New Jersey. It took a while for me to get acquainted into the New Jersey space. But once I decided to jump that way, that's what we did. 4 offices in New Jersey, 2 in New York right now. So things
Wow.
have been going pretty okay.
Amazing. Amazing. I love that.
As to the general process, I went to Rutgers. You and I were there together for a while.
Yep.
After Rutgers, I took a year to work in the business space. So I was actually a business analyst for Barclays Bank.
Oh, wow.
Turned internal project manager. And went from there into Brooklyn Law School. Got through the difficult 3 years that we had to be there for. Met some great people along the way. Had some laughs. Had some fun.
Awesome.
And then they decided to give me a law degree, so I guess I'm a lawyer now.
Yeah, I guess so.
Little test called the bar in the middle. Something
Yeah, something like
No
that.
big
Yeah,
deal.
But you made it through it. You
Absolutely.
made it through it. And so take me through it. So you finished that, and now what was your first job out of school?
So my first job out of school, I actually ran a company unrelated to law altogether while
wow.
I was in law school. So the rules in law school are very simple. You cannot work more than 26 hours per week for any employment.
Huh.
You cannot make good money working 26 hours per week. It's just not feasible.
True.
Now, at the time I started a company, I never worked more than 26 hours. And I will swear to that, and I have affirmed to that to my law school,
Good.
and I will stick with that. With that said, the only person who they could check that with is the owner of the company, which happened to be me, which was very convenient at the time in law school. But a lot of people during law school, they'll take internships, they'll get real-world experience in whatever area they're interested in. They pay those interns about $12 an hour. That
Wow.
was the case in 2012, 2013, whatever it was.
Right.
So I couldn't feed myself on that. I didn't have the benefit of, having a rich set of parents or something like that.
Yep.
They're immigrants. I think you share that with me, right?
I sure do.
So, I'm first generation born in America. And basically when I left my house at 18, it was on me.
Yep.
So when it was on me, I sat there and I said, listen, I'm making $50 an hour working for myself, or I can make $12 an hour getting experience.
Awesome.
No interest in getting this experience. A lot of interest in making money to be able to pay for my tuition.
I like that.
Hustled my way through it, managed to get out of law school debt free,
Wow.
but also with no, and I really mean this, no real world experience in law.
Wow.
So I had one internship. I won't mention the firm. They're nice people.
Yep.
But I got out and I had nothing. So
Wow.
I didn't have an offer. I didn't have a job. I didn't have an uncle or a cousin to call who's an attorney.
Yeah.
So I actually went online and was looking for job postings.
Wow.
There was an attorney looking for a quote unquote law clerk. So someone who hasn't passed the bar yet, but has graduated from law school.
Okay.
I joined up with him. I was there for about 3 months. He practices New York nightlife law, and we'll talk about him in a minute because we have a cool story about what happens with him.
That's pretty cool.
But we go over into landlord-tenant for a year.
Okay.
I represented landlords in what I call a mill. What I mean by a mill is very straightforward. It's a high-volume practice. It is, you don't really know who your client is. You don't really know the details of the case. You have a little summary on the front of the sheet.
Wow.
You walk in the morning, they give you 15 files. You go to court, you argue 15 cases based on the notes on the front. You come back, they give you 8 more. You go back in the afternoon, come back at 4 p.m., you draft some papers, you go home at 6.
Wow.
Very, very weird type of practice. New York
Interesting.
specific, I think. But high volume, and you're just sitting in court all day. For me, that was my opportunity to develop my court presence. So you put me in front of a judge for 8 hours a day, I'm going to get very good in front of a judge.
Yeah.
And I did that for about a year. And then the guy who I was working with before reached out to me. He's like, listen, how much are they paying you? I'm going to give you this much. Switch over to me.
Yeah.
So I went to my firm. I'm like, listen, can you guys match this? They said yes. They matched the salary. I stayed with the landlord-tenant firm.
Okay.
3 months later, he offered me a partnership.
Wow.
This is a 20 years experienced attorney, great guy, very well liked in the community, representing bars, nightclubs, lounges, and a couple of perhaps off-color establishments we won't talk about.
Interesting.
Keep this PG for
Hey,
now.
everybody's got to get represented, right?
Absolutely, that's 100% correct.
So-
So he offered me a piece of the pie. And
Wow.
I'd never had an opportunity to have equity stake in a law firm before.
Yeah.
So I left there and went over to him, and we represented bars, nightclubs, and lounges. A lot of real estate along the way there. There were closings at the other deal as well.
Wow.
But here we are. I worked with him for a year and a half. We had a successful practice. And regrettably, some of the ways that he practiced, he and I had different ideas about it, so we parted ways.
Happens.
Yeah. From there, I went to a firm that was a white collar, like white shoe, super fancy firm.
Okay.
We went up against all of the biggest law firms in New York.
Wow.
Pure litigation matter. I was there for a grand total of 6 months. My wife told me I could keep working there, or I could keep being married to her. It was my choice.
You chose wisely.
Yeah, well, we'll see. Ask again in a few years. But no, I love my wife. She's wonderful, and
Awesome.
very lucky that I decided the way I did.
Yeah.
But we did really cool stuff. So we got to sue Harvard Weinstein directly,
Wow.
civilly for sex crimes, which was great.
Wow.
At my
That's
previous
unique.
firm, we got to sue Cash Money Records. So we got to do some pretty
Wow.
fun stuff.
Wow, that's pretty cool.
When I left there, I knew that I was going to start my practice. I knew exactly what I wanted to do. I didn't really have a firm grasp of the things that can go wrong. I knew how
Right.
deals could work. I didn't know what would happen when things go wrong.
Interesting.
And I wanted to gain some experience on that front. So I went to a law firm called, well, I won't say who they are, but they are the biggest insurance defense firm in the country, 1,600 plus lawyers.
Wow.
Big firm. And I worked in their attorney malpractice division, where I predominantly represented residential real estate attorneys who are being sued for malpractice, which is a great way to find out everything you could do wrong.
So at that moment, is that when you decided before taking that job, did you already know basically laser focused on the real estate and you were saying, let me just figure out what the...
It was the path.
It was the path in your mind.
So for me, again, I'm a businessman. I'm going to call myself a serial entrepreneur. This is my fourth, hopefully successful business. Knock on wood.
And knock on wood.
We'll see how it goes. But this business, I had a distinct vision for it. And you and I were talking about this a little bit earlier, where it's residential real estate is a beautiful way to build up a client base.
Absolutely.
And it's a beautiful way to build relationships and get a great sense for the community, be able to help people without causing harm, which is something that I spent a lot of my career doing, was suing people and causing harm to people.
Yep.
I'm very happy to now have the opportunity to bring good into people's lives. That's really
awesome.
what I'm concentrating on at the moment.
I love it. And it's such an emotional moment for a lot of people, myself included. I mean, anybody I talk to is the same. You know, it's you're buying your house, and most of the time, for most people, that is the largest purchase you're going to make in your lifetime.
Absolutely.
You know, and that moment is very emotional, and especially in a market that we've had in the last 2 years. I mean, it's emotional, it's wild, and it is just, you know, nonstop. I've spoken to realtors, I've spoken to the mortgage loan officer who's been on the show as well before, and everybody's got a similar tale of the craziness. So really cool to see you kind of put it all together and have that path with laser focus like you did to be able to understand what can go wrong, what can be good, and now bring that all to your clients. And when did you launch your firm?
So we officially launched October 8th, the day after my wife's birthday
good.
of 2020, right in the middle of the pandemic.
Amazing.
Yes.
Wow.
So we just celebrated our 2-year, I guess, last week.
Yeah.
Which has been very exciting. And that was our start point. Yeah, thank you so much.
It's amazing, man. And what a ride. In many ways, I'm sure, again, with the pandemic going on, with the craziness of the market and managing expectations and everything, which really brings it all in. So great intro, really brings it all in to what the point and what the purpose is here. I want to take everything that you've learned on the real estate side, everything that you've learned in the last 2 years, now being on your own and helping the residential real estate community, and really dumb it down. You know, and I don't mean to say that obviously in an offensive any kind of matter. I just mean let's bring it to a level that is digestible, that we can help out all the listeners who are going through a transactions or about to. And the goal in my mind is twofold. One, you know, I want someone who is saying, oh, I kind of want to buy a house, you know, and I'm ready for it. Well, before you jump in and you do everything, listen to this for 45 minutes to an hour. Listen to Andrew tell the side from the real estate attorney's perspective. Listen to Matt, who was on the show earlier on, talking about the mortgage lending side. And if you listen to this season 1 of real estate, you will hopefully, you know, be able to at least have some understanding of the process, even the basics. But at least you won't worry about all the different things and what they mean, which is what I felt, you know, in my transaction. So, you know, let's get to the basics.
Absolutely.
So let's start with, you know, what is the role of the real estate attorney? We can start with that, and then you can take it from there, kind of, and we'll let it go from there.
Absolutely. So when we are north of what I call the New Jersey Mason-Dixon line, which separates North and South Jersey chooses not to use attorneys for most residential transactions.
Interesting.
That I'll tell a fun story about that if you like in a little bit, but lawyers did that to themselves. It was their own decision.
Wow.
But if you're in North Jersey and you're working with an attorney in order to get a closing done, the purpose of the attorney is to set the rules of the contract. Obviously, once the realtors get through, and we'll talk through that in a little bit. We are the interface with the other side, We are the ones protecting our clients and basically being their legal hands, if you will, and interacting with the other side's attorney.
Right.
So a large part of this comes down to the contracting, the very beginning of the process, which we talk about in attorney review, and we'll go through the stages in a second, where we're setting the rules of the game. We're just agreeing on what's going to happen. If X, then Y. What are all the conditions? What are all the contingencies? I like to say that there's 10,000 things that can happen from saying, hey, I want to buy a house, I want to sell a house, to, hey, I bought a house, I sold a house. And we need to be able to contract and control for all of those things and understand the consequences of our decisions. Now, my job is to protect my clients and fight for them in that front, and then see them through and guide through the rest of the transaction. A lot of people like to refer to the real estate attorney as the quarterback of the deal. So we're calling the plays, we're the ones sitting there and making sure that our team is protected and making sure that everything gets done. We're the ones that are going to ultimately, have a large part in whether or not things succeed or fail.
So, let's take it from the moment, for me, for example, most of the time when the thought comes to my head of I'm ready to buy a house, I'm thinking, let me hop on Zillow, let me find a realtor. In my mind, I also knew the numbers, being a CPA, all that. So mortgage loan officer was certainly there. So at what point, would you recommend that someone reach out and try to find an attorney?
So here's the best time to do it is while you're hunting. So if while you're hunting, you've already established your team, you've had your intro calls, you are going to be more informed than 90% of buyers, maybe probably higher than that, 95% of buyers. The way it usually works is you get your pre-qual. If you didn't get your pre-qual, your realtor will tell you to go get your pre-qual. They'll introduce you to good lenders. They'll introduce you to people they're comfortable working with. But you then go and you find a house. You submit offers on a house, especially in the past 2 years. It hasn't been you submit an offer. It's you've submitted 75 offers before you finally hit. And then you get that offer accepted. And as soon as that offer is accepted, we'll talk about the mechanics of it in a second. Once that offer is accepted, that is when the attorney scramble starts. When all of a sudden you realize you need a lawyer today. You need a lawyer tomorrow. And who do you reach out to? Whoever your realtor recommends. Well, unless you have a personal connection with somebody. You generally say, oh, they're comfortable working with this person, I'll work with this person. And that's great because realtors have a great knowledge of the industry. They haven't done the one deal that you're on. They've done hundreds of deals. And as a result, they've built their relationships with the right people to allow for a successful relationship, a successful transaction. And you should listen to your realtors. That doesn't mean that they're always going to recommend the person who is best for you. And I don't claim to be the best attorney for everybody at all. And a large part of that first phone call is understanding whether or not we're going to be able to work together correctly. But to me, if you already know your team when you're submitting your offer, you're going to look very, very organized. The realtor can submit your offer with the list of who you're going to be working with, and it's clear that you're a serious prepared buyer. So that's going to help you on the front end. And then more importantly, when I talk to my clients, that first phone call, I tell them everything that's going to happen from the start of the deal until they finish the deal. That is part of the service that I offer. And if you don't retain me, that's okay, because at least you're going to be a little more well-informed. Maybe you decide my prices aren't right. Maybe you decide my personality is not right. You want someone who's a little bit older. You want somebody with a a higher-pitched voice, whatever it may be. That's fine. There's nothing wrong with that. And I'm perfectly comfortable not working with every client. But I would hate for someone to get on the phone with me, talk to me, understand, and hear what I have to say in the area that I specialize in, and not walk away a little bit more knowledgeable than they were when they called. So that, to me, is the big key. So many people get their offer accepted and go, uh-oh, what do I do now? If you talk to an attorney ahead of time, they're going to draw everything out for you. They'll explain for you what's coming. They'll know exactly what's going to be occurring. And that's going to make you feel more comfortable, because when you get that call, congratulations, the offer is accepted. You already know what's going to happen. That moment is beautiful. It's just, it should just be pure joy. It shouldn't be joy and panic. And the best way to prepare for that is by knowing your team ahead of time.
I love it. And so, what you just said gave me an idea. And let's run, if you don't mind, let's run through that call that you would have, because I think that right there is the meat and potatoes of what we want to talk about here. That call, where you're getting that phone call from the intro, the first-time client, hi, Andrew, you're recommended to me by my realtor. I'm in the process of hunting for the house. I think I found one. I want to put an offer in. What is this? What are the steps? What should I be knowledgeable about And how do I prepare myself for this whole ordeal that I'm about to go through?
Okay.
Take it away.
So here we go. We're going down the road, and I'm going to preface with, we talk about submitting an offer. And as an attorney, I hate that term.
Yeah.
Because we're not submitting an offer, we're submitting a contract. And the New Jersey legislatures have decided that the way things are going to work, at least in North Jersey and central North Jersey, is that we are going to have realtors draft a 14-page contract, and we're going to call it an offer. And the reason we call it an offer is because it is, in fact, a fully drafted contract. And it's an offer because if the seller signs it, then they have accepted the offer, and now we have a contract. And people don't think of it this way. And the reason they don't think about it this way is because of paragraph 35 of that contract. And sorry, this is a little industry knowledge, so we won't get too deep into it. Paragraph 35 says the words attorney review, and it talks about how things go down in the attorney review process.
Interesting.
So you signed a contract, the seller signed off on it, you now are in a status, as I like to refer to it, as offer accepted.
Okay.
And what we need to do is get from offer accepted to under contract. That is the next step that we go through.
Correct.
And the process through that road is called attorney review. Now, we're going to get into the mechanisms for a second. The first thing that happens, and there's very specific language that has to be used, is the buyer's attorney, by custom, there's nothing preventing the seller's attorney from doing it, by custom it's the buyer's attorney who does it, sends out, it used to be a letter, it's now an email. The Supreme Court or Superior Court has decided that is sufficient, and we could do it by email, which is we're very grateful to be in 2022, saving on postage, though I think it's hurting the USPS, but it's neither.
That's a different story. Yeah.
Exactly. So you send out a letter that says, hey, I've reviewed this contract. I, as the attorney for such and such party, disapprove of it. And that word disapprove actually is magical. If you don't use the word disapprove, it does not have all of the next things that we're going to talk about associated with it. And that actually breaks the contract, which sounds very scary to a home buyer who is planning on purchasing a house. The last thing they want is to break the contract. But that is the process. That is what happens on 98% of deals. We send a disapproval letter, and we send out a document called a rider. Rider is a series of changes that we want made to the contract.
Okay.
And as the buyer's attorney, I have one goal only. I want to get as many representations out of the seller as possible. I want them to make promises to me. And I want to reserve back-out rights because when things go wrong in a deal, I need to protect my buyer. What does a buyer want when things go wrong? They want to be able to get out of the deal and get their deposit back. Correct. From the seller's side, I want the exact opposite. I represent sellers. I want to make no promises whatsoever and to not let you out of this deal no matter what. I want to limit the buyer's ability to get out. And we'll talk a little bit about the different clauses and things that go into it along with the stages, but let's put a pin in that for now.
Yes.
I send out a rider. The seller goes, Andrew, you're nuts. I'm not giving you all this. Here's the subsection of stuff I'm willing to give you. I say, okay. Me and him, or me and her, push things back and forth. Or whatever other pronoun is correct. My apologies. We push things back and forth and things until things are pretty much agreeable between the attorneys. Then we turn to our clients.
Got it.
A lot of attorneys sign on their client's behalf, which is legal under a precedent that's been set in Superior Court. I don't do that. Yeah. My firm never signs on behalf of our clients unless it's just a feasibility thing. They can't get in front of a computer. They say, Andrew, we're good. Sign it for us, please. And they give us an email sending, please sign it. We don't sign anything. The reason we don't sign anything is twofold. First of all, I never want a client to say, I've never seen this document. Put your signature on it. I know you've at least seen the document. You chose not to read it. It's a different situation. And the second thing is I never, ever, ever want clients signing things they don't understand. So my firm's process, the way we work, is we finish the negotiation with the other attorney. Everything is subject to our client's approval. We then send it to our client. We say, dear client, here's the base contract that you signed that you most likely never read because nobody ever does.
Because they're trying to just submit an offer and get it accepted.
Yeah, because you think it's just an offer. So you never read that document you're signing, even though it's a 14-page contract. If no one disapproves of it, that's going to become legally binding.
Wow.
And there's 3 days to disapprove of it. If no attorney in 3 business days disapproves, that contract is binding. You are under contract. That's it. So yeah, that's a really weird kind of facet of it.
Let me pause here for a second because we just touched on a lot of stuff, and I want to really hone in on what you said in the process. So, you're looking for a house, you find a house, you put an offer in, right? And you contact your attorney. As Andrew just explained, that offer is actually a contract that is drafted by the realtor. So make no mistake about it, as Andrew just explained, that offer that you're signing and for the purchase of this house is an actual contract that if no attorney looks at it,
will be binding.
Will be binding. So what Andrew then said is the next step with the attorney, if the attorney has been selected and you're receiving this contract, now you're saying, I disapprove. Most of the time you probably will end up because there are some certain clauses in there always. So there's going to be this magical word, I disapprove of the contract. And now, as Andrew mentioned, rider. So I've seen this word rider. What that means is now is almost like what is addendum similar to rider?
They're the same word.
Okay.
An addendum to a contract is distinct from a rider by only small legal differences that make no difference to the average person. They are separate documents. Riders tend to be standalone. Addenda tend to be attached to the contract.
Got it.
But that is the only distinction. They're the same thing. So don't stress out about it from a common person's perspective. It makes no difference.
Yeah. So now, whatever the attorney is, and in this case, Andrew, would take this contract and, tear it to shreds, so to speak, in the sense of, what is
certainly not tear it to shreds.
Not tear it to shreds like this, but tear it to shreds with, looking through it and making sure.
We elaborate. Honestly, at the start of this, before the attorneys get involved, the buyer knows the deal. I'm going to pay this much. I need to get a mortgage commitment by this point. I need to close by this point.
Yeah.
Those are the basic terms the buyer's familiar with, right?
Right.
The seller knows I'm getting this much money for my house. The closing's around here.
Yep.
If we stripped every other provision out of that contract, the attorneys would not be needed in the least. It'd be completely unnecessary. There'd be no reason for lawyers to be involved.
True.
But there are all of these things that happen along the way, and that is what we're doing. We're not changing the heart of the contract 99 times out of 100.
Yeah.
What we're doing is just setting the rules of the game from I want to buy a house to I bought a house and everything that can happen in the middle.
Got it. So that's what that rider is. Now the rider is submitted by this point. Let's say who's the first person? So the contract is signed.
Offer is signed by the buyer.
The buyer.
The seller's countersign. The realtors then circulate it to the attorneys.
Got it.
And typically the buyer's attorney sends the first rider.
Okay. So buyer's attorney is going to send the first rider. So if I am the buyer in the situation, and you're my attorney, you're going to say, okay, I disapprove of the contract as written.
Right.
Here is a rider or an attachment or
Proposed
whatever it is,
rider.
Proposed rider with the terms that I want to protect my buyer with.
If the seller agrees to this, the buyer will countersign and will be under contract.
So so assuming if they approve immediately, there you go. You're good to go. Easy. If they then go back to you, which they always do, and they say, wait a minute, I don't like this, I don't like that, and they redline it or they do whatever, come back. Eventually, at some point, this is the process of attorney review.
Correct.
So this is the process, which now, to take a second, I know from just general knowledge, attorney review is 3-day process.
So, misunderstanding.
Okay.
Attorney review is an unlimited time process.
Interesting.
So plenty of deals die in attorney review. It's not as though in 3 days everything is automatically done, right? What happens is you have 3 business days from the day of signing of the contract. So the first day is day 0.
Right.
You then have 3 business days for one of the attorneys to disapprove. As soon as one of the attorneys disapprove, the contract is technically broken. And the process of putting it back together can take as long as necessary.
Ah, interesting. Okay.
So that's a common misnomer in the industry.
And that process of putting it back together
is attorney review.
Is with these riders.
Yes, sir. Correct.
And then so that's perfect. So that's a really good clarification. And sometimes that could take 3 days, and sometimes that could take weeks.
Correct.
Right?
I have one right now that's been ongoing for 3 weeks. It's one of the longest attorney reviews we've ever had. The reason is because it's a complicated deal.
Right.
And there are things going on there that are atypical. There's a lot of due diligence being done on the front end that's typically done later.
Got it.
And as a result, the negotiation is just becoming significantly more complicated. It's not normal. Our attorney reviews are generally done within 48 hours. That's
48
our
hours.
golden rule. Assuming everyone's responding within 12 hours of receipt, we should be able to get it done in 48 hours.
So you go back and forth.
Yes.
You get that final, everybody agrees on the final rider.
Correct.
That has gone back and forth.
Or riders
in K because they're going back and forth. Now, that step is when it's all signed, it's called being under contract.
Right. So buyers sign off, sellers sign off. We're now under contract. The significance of being under contract
what does that mean?
Is prior to that point, anyone can back out anytime for any reason. I realized I hate the pink paint on the walls is a good reason to back out during attorney review. I don't suggest doing it, but legally you have the right to.
I see.
The seller's face is ugly is a good reason to back out when you're in attorney review. You could do whatever you want at that time. Now, once you're under contract, your only way out, whether you're the buyer or the seller, is with a contingency, which is a very fancy sounding legal word. So let's get rid of that and just say an out. What are your outs?
Yeah, hit us with the outs.
The typical outs from buyer's side. You've got your inspections. We'll talk a little bit about those in a second. But essentially checking the physical status of the house and the things around it.
Makes sense.
You've got your mortgage, assuming you're using a loan and it's not a cash deal. If you can't get the money to buy,
Got it.
you can't buy.
Yep.
And you've got your title. Title is making sure, it's extremely important. If you haven't had a title person on your show yet, you need to do so. Because they will explain things to you that nobody else is familiar with. I have to interact with them, so I have a baseline knowledge, but I do not have to deal with the title underwriters.
I like that. I'm going to take care of that today because I haven't thought of that yet, but thank you.
Absolutely. So title is your insurance that as of the day of the closing, you own the property. It is only yours, nobody else's. There are no judgments, claims, or liens against the property. And this is very important, it tells you what your restrictions of use are. So everyone thinks I buy a house, I could do whatever I want. I could, shoot off fireworks. It's my house. It's my thing. I could do what I want. It's not the case.
Interesting.
Most land has certain rules around it. And you want some of these things, right? So you want electricity. That means you need to give an easement to an electric company to run a wire to your house. You want water. You want water line going to your house. You want to be able to flush your toilet. You want a sewer line to your house. For them to come onto that property, they need easements. They need a right to do so. And their establishment of those things is in writing. It's part of the record, and it's an exception to your ownership. You can't do whatever you want. You must allow these pipes to go. You must allow these wires to go. And that is the way that it is done. It's very important to understand. From the average consumer side, as far as title goes, very simple. Your lender requires it, so you're going to get it.
Which is most things, really.
Yeah, 100%. The lenders drive the whole industry. But that is our last out, is if there's something wrong with title, if there's a cloud on title, a defective title, we don't have to buy the house.
Got it.
That's on the buyer side. On the seller side, there are literally two contingencies. The first one, very simply, is your CCO, which is your resale requirements. We'll talk about them, I imagine, later in the show.
We shall. But let's just real quick, since you said CCO, that's
Certificate of Continued Occupancy, which is a catch-all term. It is, in fact, just whatever is required from your city and state in order to sell a house. So there are rules that govern those things. And there is a standard provision in the contract, paragraph 9, specifies how much a seller has to spend on getting these CCOs before they can back out of the deal if the buyer is not willing to pay the delta. It happens almost never. In the past 1,000 deals, I've had one that used this as a sword, but it is technically a contingency.
Okay, and what's the other one for
the other one is the timing of the buyer. The buyer has made certain promises to do certain things in a certain period of time. If they do not perform and they can't get things done, you can give them a notice. If they don't get it done within that notice period, they're out. You could back out of the deal.
Okay, got it. We'll definitely jump on that because I know what we're talking about here. But all right, so let's go through on the buyer side. Let's talk about those outs in order. Now, inspection.
Inspections
one
tend
of the
to go first.
Yeah, let's go first with that because I remember from my process, we went on the contract officially, and we were allowed to request and make the appointments for the inspection.
So when you were doing that, were you allowed to do any inspections that you want, or were you limiting your inspections?
So I was part of the offer that was put together was that we limited hours to structural,
Mechanical,
environmental,
Standard.
which standard, and especially I guess in the
crazy sellers market we've been in, extremely normal.
Yes.
Now, let's talk about what all of this means. So let's back it up for a second. I do want to just make a quick note. There's a separate thing from inspections, mortgage, and title that's very important as a buyer. You must give an earnest money deposit.
Yes. Oh, good point.
The earnest money deposit tends to come before everything else. The timing of it is set in the contract and it's negotiated in the attorney review. This money is going to be held by an escrow agent, typically either the seller's attorney or the title company. Occasionally the buyer's attorney will hold. And it doesn't matter who holds. I tell all my clients I couldn't care less who's holding the money because whoever's holding it, they're not allowed to release it unless the other side gives permission.
Okay.
So whoever holds it, they are duty bound, legally bound, going to get sued if they give that money to anybody without permission.
Got it.
That's completely impermissible. So whoever's holding it, they're sitting there and just holding the money until the closing or until the deal dies. If the deal dies, generally it goes back to the buyer unless there was some impropriety. If the deal closes, it goes to the seller as part of the purchase price. And you get a credit for that amount. Very straightforward, but very important to do because if you do not give that deposit as the buyer, they can give you a notice. You don't give that deposit within whatever that notice period is, typically 3 days. You're out. They can go and sell it to somebody else.
Got it. So that makes sense. So that money exchanges hands, goes to the escrow of whoever. Let's just call it the buyer's, the seller's attorney, the buyer's attorney, whatever it is. Now it's time to schedule your inspections. And what are some considerations? What are inspections exactly? And how can they make a deal die?
Got it. So Three things to note about inspections. The first one is the different types of inspections that there could be. Inspections are generally your broad home inspection.
Okay.
If there's a pool on the property, there's a separate pool inspection. If there's a septic tank or septic field or septic system, there we go, on the property, there's a septic inspection. You will usually, as part of your home inspection, do a radon inspection, which is a separate odorless gas that can, in sufficient quantities and breathe for long enough, cause lung cancer. So it's important to check for, especially if you have any underground floor. And you will occasionally have a chimney inspection done. There are some other inspections that can be done based on people's concerns. You can have a structural engineer come in. There's countless different things that you can do for inspections. You can do mold inspections if you see something that looks like mold to confirm it. A lot of different things that can be done. The purpose of all of them is to take an average person. I consider myself as an attorney to be an average person. I imagine you consider yourself as...
Absolutely. Especially in the real estate.
Yeah, you're an average person. As an average person who is not a professional in finding things wrong with houses, you don't generally go to your friend's place and go, oh, hey, that crack is shifting. It might be a structural issue. That's outside of our knowledge. I go to a house, I see a little crack in the wall. I'm not scared of it. Why? Because I don't own the house. Now I'm about to purchase this house. I want to know if that crack means that I'm going to have to re-pour foundation, if that wall's going to come down, if my flooring's about to all come up like this as a result of that crack. Now it's a lot more important to me.
Good point.
I don't know what mold looks like. I've seen mold. I've seen pictures of mold. I've seen things I'm sure I know that's mold. And then they go and do a swab and it's not mold. It's dirt.
Interesting.
Why? Because we're not experts. That's not our field of expertise. Now, you have an inspector come in. He goes, that's mold. He still doesn't know because he needs to run lab samples to confirm it. It may look like mold. He may tell you, hey, that's almost certainly mold. The average inspector doesn't have the license to run the mold test. And that's one of the things that comes up. We'll talk about in a second. But why do we do all of this? To know what we're getting ourselves into. I'm going to buy a house as an average person. I walk through. It's beautiful. I can imagine my family sitting there. I could see the living room, the TV hung up. I can see my kids running through it. That's it. I'm a happy camper because it's a beautiful looking house. That's not enough. You need an expert to come in and say, listen, I'm not telling you not to buy this house, but here's the things that you're going to have to deal with. Here are some concerns that I have. They make a list. They make a report for you. Now, a lot of inspectors do what I consider to be a great job. And a great job is someone who comes in and tells you the concerns. They don't scare people. They don't sit there and make people worried about the entirety of the situation. They explain to them the situation. They may help them understand the things that they could do and the upkeep that needs to be done in order to prevent issues in the future. And they're going to point out if there's something glaring, if my roof's about to fall down, I need to know about that. So it's important to point these things out. The consumer has a right to know what they're buying. That's what's important for it. That's why we do our inspections.
And I think it is extremely important to pause here in what you said and really focus on the inspection. But to me, personally, it was the most important part of more or less the entire process, right? Because yes, signing, yes, getting all the terms and everything like that. But just like you said, I walked through this house and I'm saying, wow, I love this house. It's perfect. But what is hidden underneath those walls, or behind the walls rather? What's in the basement? What's in the attic? What's the status of the foundation, of all those things that could potentially go wrong? A month after, hopefully not, a year after,
5 years, 10 years.
5 years, 10 years.
Absolutely.
And this moment where you're picking that inspector, I think is a really, really important moment. And, now let's talk about, so all those items that you could be testing for, as you said, radon, general inspection, structural inspection. I think there's also wood destroying insect.
WDI is part of the standard home inspection. You're going to be checking for your termites, your carpenter ants. You're going to be checking for your carpenter bees, anything that could be eating the wood in your house.
Correct. And out of all of that, now it's done. I remember my report was like 100 pages long.
Yep, they all are.
They all are. It's probably a standard. And then, like you said, I was not scared by anything in that report. We had a very thorough inspector. But now what is the next step? Because in my mind, the next step is, okay, there are some really big ticket items and there are some small ticket items.
Absolutely.
Let's talk about this next part. Is it the credit? that you now are trying to seek?
So the idea of a credit in regards to inspections is we're going to hit, this is number 2. The first one we talked about, the 3 days attorney review.
Yes.
This is number 2, giant misunderstanding in the industry.
All right.
In the seller's market that we've been in, we're still in a seller's market. We're still in an inventory status that makes it a seller's market.
Yep.
The norm is as follows. A buyer has a right to request repairs, never a right to request credit.
Interesting. Okay.
A lot of buyers will say, hey, here are the things that I want, or I'll take X dollars in credit. You're allowed to do that. That's permissible, no problem.
Fair.
But typically, your only right under your inspections is to point out the defects in the house that you want corrected.
Right.
And furthermore, it's limited to however you limit your inspections. So you limit it to mechanical, structural, environmental, which is a normal limitation in this market. But when you make that limitations, if it doesn't fall into one of those buckets, you don't have a right to ask for it. You have to accept anything that doesn't fall into those buckets. And not everyone understands what those things are. Not everyone understands what those things mean. And you'll find that this is actually a problem we encounter with realtors who don't explain to their clients well.
Yeah,
because
absolutely.
again, this is being submitted before they talk to me, right?
Correct.
So I come in, I go, well, this says only structural. I just want to make sure you understand if your furnace is out, you have no plumbing and you have no electricity, you're buying this house. They go,
Wow.
Well, that's not what I agreed to.
Yeah.
I go, no, that's exactly what it says because you said structural only.
Wow.
So
that's a good point, man.
and that creates a big problem. That's a very scary thing because obviously nobody wants a house with no electricity, no plumbing. I mean, unless they're a contractor, and that's a very specific deal. But that is a huge concern. So when we're limiting our inspections, we have to understand what that means. And what it means is when you go to make your request for repairs, you are limited to the buckets that you've delineated. Now, I make a list of repairs the way we do it at my firm generally. I have one rule when I work with realtors. I ask them, please be a part of the inspection conversation.
Right.
Why? Number one, I'm sitting looking at a report. It's 100 pages long. I make sure that I read it. I make sure that we know what's going on with the house. I need to know what's happening, right? So I need to read this report, but I'm looking at pictures, and sometimes I get reports without pictures where I'm literally just reading words. And I'm sitting there, I haven't seen it. I've seen reports that make it sound like the house is falling down. And I go on Zillow, I look at the pictures, the house is gorgeous, and the inspector's making mountains out of molehills. I've also seen reports that are like, oh, there was a little bit of liquid in the basement, and then I see the video, and there's a foot of standing water. Where inspectors do a very good job of explaining things to their clients, but the report itself is insufficient. You need to be there. And this is my number one recommendation for buyers. Be there for your inspection. You should be there. The inspector will point out so many things about your house that you'll never know otherwise. It is incredibly valuable. And past that, you're going to be able to be like, hey, is this a big deal? And the realtors who are there, they typically attend the inspections as well. They have been privy to this commentary where the attorneys have not. So I say to my realtors, I'm like, listen, make sure that we're not focusing on the wrong things here because they know better than we do for having seen it. So generally a realtor will get on the phone with me. They'll say, hey, Andrew, here are the main concerns just to guide your conversation with the client. Then we hop on a call with the client, or sometimes we'll write up the request list based on that preliminary call. We'll send it to the client as a start point of our conversation. And we talk to the client. We say, hey, what are your concerns? What do you need fixed? In the seller's market we were in, the conversation was, if they don't do what, are you backing out of this deal? Because it wasn't about what do you want. It was about how do we make sure this deal doesn't die? Because nobody wants to go submit another 75 offers. Now the market's balancing a little bit. We're seeing a lot of shift in that direction. Thank God. Now it's, hey, what will make you comfortable? You talk about your must-haves and your like-to-haves. And we go for all of it and we negotiate it from there. But that's just a change in the market that's allowing us to do that.
Yeah, that's interesting. That's a really good point. And especially before you, that's a good description you used. It's almost like, okay, realistically speaking, what are your sticking points? What's the real, what's your real hold up here, if you will? Because if you're going to lose this deal, and I could tell you, like when I was submitting the offers, I mean, it was basically like, okay, we can get this offer, let's say at X amount. If on the inspection, I think it's going to present better if you say only, structural, environmental, mechanical.
Absolutely.
Or take away mechanical if you're going to redo, whatever stuff.
Anyway, if you're redoing it, or if you know it's coming with the home warranty, or they just redid all of the mechanical systems. There are situations where you're willing to change it. But what I'll tell you is, and this is really important, the big key to all of inspections, and we're getting into like the dirt here. We're getting into the into the serious stuff. I want to take just a step back and understand, buyers, Unless your attorney gets it for you in attorney review, it's very difficult to do because most seller's attorney will not give it to you in the current market.
Right.
You do not have a back out right based on just the inspection.
Interesting.
You can't see all the things wrong and go, oh my God, I don't want this house. It's not how it works. You have to submit your request of repairs. And if they deny to make those repairs, the ones that you were allowed to ask for based on your limitations, then you have a termination right.
Okay.
So we create these lists. We talk about making sure we have a certified insured licensed contractor, making the repair that we want done. We delineate the exact repair. My firm, we point to the exact point in the report where the defect is listed to make things a little bit easier when they're analyzing it from the other side. And we say, here's all the things that need to be done. Or if you'd like, we'll accept a credit of this much if that's something that my client has calculated, which they generally don't, because to get those calculations, you need to do estimates, and that takes time, and everyone's in such a hurry in this process that generally we don't have that. So we submit that. The sellers, they have three choices. They can agree to make all of the repairs, at which point the buyer's stuck. They no longer have back out right. They can offer a credit, at which point the buyer now has a full termination right. That offer of a credit is a rejection to make the repairs, which gives us the back out right. And then we can negotiate the credit or we could walk. Or sometimes sellers say take it or leave it. And they say, buyer, you want to walk? Here's the door. You make a decision what you want to do.
Wow.
And that's the negotiation. And we push back and forth. We advise our clients. There's a lot that goes into these conversations. What I'll advise buyers is if we're talking about a credit, do not micromanage the negotiation. I promise you, forget the attorney for a second. The realtor on the deal has done more negotiating in their life than you have. 100%. Let's say 95% of the time. Tell us where you want to be. If the answer is always more, you'll always be disappointed. Tell us realistic guidelines of where we need to be to make this deal happen for you, and let us work on the strategy between the attorney, because the attorney has to do the official negotiation. When I make a demand and say, if it's not this, we're walking, that's legally binding. At that point, there is no informality to it. The realtors sometimes get on the phone, hey, do you think your guys would do this? No, they're really stuck at this. Then the realtors come back to the attorneys and we set the negotiation strategy based on this informal conversation. But when clients start to micromanage it, they inevitably shoot themselves in the foot. The quantity of negotiation that is done by the average client is so much less than the realtor on the deal and the attorney on the deal that they're really doing themselves a disservice.
Wow. That's really, really good stuff. And, it's worth to kind of, I almost want to say, let's give it an example, right? So you're in an inspection, something is found, or,
so let's not even go that far. We're making our list. We're making our list.
Give me an example of something.
I have clients who say, the floors are crooked. We need them to be corrected. The window seal is blown, which is a thermal issue, which, by the way, is outside mechanical, structural, environmental. Not that anybody wants to hear about that. The grading on the house is towards the house, so water runs towards the foundation instead of away from it. It's a result of settling. You put thousands and thousands and thousands of pounds on ground, the ground's going to go down. And unless you do your landscaping correctly, it's going to go the wrong way. The gutters need extended. We have stuffed up gutters. The vents to the house the vents from all the bathrooms are going into the attic. They're not venting to the outside of the house. Here's our full laundry. There's 10,000 things going on. This light fixture doesn't work. The polarity on the sockets are reversed, which sounds scary. You literally just open the socket, switch the wires. You're done. It's not so scary. There's no GFCI in the bathroom. I mean, there's 1,000 things that go wrong.
Absolutely.
And I have clients who say, tell them I want everything. And I go, if you ask for everything, you're going to get less. You're going to get less than if you laser focus on the things that are important to you. And some people will listen, some people will not. I have a client, I won't talk about names, obviously, but right now, one of the standard carve-outs, good seller's attorney puts this into their rider. The age, any system that is past its useful life but still properly working is not a defect.
Correct.
So, you got a water heater that's rated for 15 years, it's 20 years old. Buyers go, I know this thing's going to go. I don't want to buy this, but have the seller replace it. That's not a defect. That's not an issue. Correct. So I had that exact situation come up recently, and I said, listen, ask them to fix the bonding wire, which is actually a safety concern. They're not going to do it anyway. They're going to give you a credit. They'll give you a credit for getting the plumber out, which is a minimum of $200. You're going to get that credit for the $60 of work for bonding wire. It's nothing. But if you ask for that, which is a legitimate concern, they're going to include it in their credit offer to you. And the client goes, no, ask them to replace the water heater. And sure as anything, the seller's attorney turns around and goes,
Nope.
No,
Yeah.
this isn't part of your inspection. There's no defect. Have a nice
Wow.
day. And we got $0 for it.
Yeah.
And we could have gotten more.
Yeah.
Candidly. And we didn't because the client micromanaged the negotiation.
Right.
Now,
Interesting.
we cannot act without our client's permission. Our jobs as attorneys is to be the legal hands, right? So we
Right.
are doing the negotiation. But if you tell me go do X, I'm going to go do it.
Yeah.
I can advise you that you don't have a right to it. If you ignore me,
Yeah.
and then the other side tells you, well, hey, you don't have a back out right, you don't have anything in regards to this item,
Yeah.
we're just striking it out, that's on you.
Yep. Interesting. Yeah. So this whole part of the process and getting the repairs done versus getting a credit. Do you find that most of the time our sellers just saying, okay, forget it, here's your credit, or
For the past few years, yes.
for the past
So
year
for
just
the
to
past
get
few
through the
years-
process?
It's not to get through the process. For the
Yeah.
past few years, sellers have been elevated to this platform
Mm.
where they're not doing anything. They don't want to do anything. They're doing the bare minimum to just be done with the
Yeah.
deal. You go back 4 years,
Yeah.
it was way more common to do repairs. Right now, sellers are getting paid so much for their houses
Right.
that
They don't care.
they're just like, oh, I'm going to lose $5,000? Okay. I'm still getting 50 over what it's worth.
Yeah.
So they're just not concerned about giving up some money.
Right.
And also footing the cost from the seller's side is less convenient than
Right.
just giving a credit.
Yeah. Yeah, absolutely. So yeah, and it certainly is. And I rather than going in there and doing the repairs. And then just real quick on the repair side, if they do the repairs, but it is not to standard to code, what happens then? Do you need to do it again?
A good attorney
Yeah.
does not just say, fix this.
Yeah.
They say, have a licensed, certified, insured contractor fix this.
Right.
Have a contractor fix this. Have this person fix this. Whatever it is, you specify how the repair must be done.
Yeah.
A licensed contractor, a licensed electrician, a licensed plumber,
Yeah.
they're not signing off on shoddy work.
Right.
Because that's their license on the line.
True.
And when I see an invoice and I see a contractor putting their name on the line, I'm
Right.
very comfortable that the repair is done correctly. With that said, if the buyer wants, they can go and say, hey, I want a plumber to confirm the work is done correctly
Yeah.
and foot the cost to do so. Most buyers won't. They don't want to spend the money.
Right.
But if it's not done correctly, then it's not done. And if they're not willing to do it correctly, then they've rejected the inspection request. And
Right.
if they have rejected the inspection request, I, as the buyer, have a back out.
Right.
It's that simple.
That's a good point. I'll stop dwelling on the inspection, even though I feel like there's so many ways.
There's
you
so
could
much
go,
to go
you
into.
know,
We could talk about inspections for 2 hours.
Yeah, for
I
2
mean,
hours
it's
straight.
easy.
So now let's go to the second out for
Mortgage.
for the buyer mortgage. This one is an interesting one, right, to me, because I was chatting with the mortgage loan officer before this, like I said, on episode 1 of this show.
It was with Matt, right?
It was Matt. Yep,
great
Matt
guy.
Schofield.
Great
He's
guy.
fantastic. And we were chatting about all the potential things that happen in a mortgage and what can go wrong and not being funded. And the mortgage is I would say, even more stressful than the inspection, because that could go down at the 11th hour and you may not.
There's
it.
a lot of misunderstanding here, right? So
Yeah.
I am not going to talk outside of my field.
Yes.
I will talk about the general experience from my side in regards to mortgage.
Perfect.
The most important things here when it comes to mortgage are understanding who you're working with
Yep.
and understanding who they are in the process. So generally, there's this giant misunderstanding about who you're talking to.
Yeah.
The first person you speak with in mortgage is generally the sales individual.
Right.
They call themselves loan officers from time to time. They are generally the person whose job it is to bring you in,
Yep.
get your information enough so that you can go and push the loan to processing.
Yep.
Then all of a sudden, person 2 calls you out of nowhere.
Yeah.
I've been talking to Mike this whole time. All of a sudden, John calls. Who's John?
Yeah.
Oh, yeah, I'm the processor on the deal. Here's what I need. The
Yeah.
processor's job is to line up all of the conditions so they can submit it to the underwriter.
Right.
The underwriter is a giant black box. Every single loan company I work with, this underwriter is a giant black box.
Yeah.
What that means is we don't know when they're going to do it, we don't know how fast they're going to do it, and we don't
Yeah.
know what they're going to do. Why? Because they are the guard to the vault.
Right.
The underwriter is the one who decides whether or not we're going to take money out of our pocket and give it to you to go
Yeah.
and get a loan and buy a house.
The bank. That
The
is
bank. They are the bank.
specifically.
Yeah,
Yes.
of course. So they are the bank. And ultimately, the underwriter is the keeper of the gate. So everything that happens on the front end,
Yeah.
all of the paperwork requests, all of the documentation you have to
Forms.
submit, all of the forms to sign, all of that is just queuing you up to go get an answer from this underwriter. And it comes in two major stages. One, which is your commitment. We'll talk about that in a second. And two, which is your clear to close, which is when we all jump up and down and know we're buying a house. Which is great. The mortgage commitment is the bank saying, we have enough information to know that we are going to give you a loan. And typically you have 30 days roughly, sometimes 45, sometimes 20, depending on the situation, to go and get that mortgage commitment. That mortgage commitment is always conditional. When I say always, I mean I challenge anybody who listens to this. I hope you have 10 million viewers, listeners, so that we have 10 million people go and check when you bought your last house to go look for that mortgage commitment. You will find a list of conditions that is extremely not short.
That's a good way to put it. Extremely not short.
It's extremely not short.
It's true.
The first mortgage commitment that's given usually has a ton of conditions on it.
A ton.
Some banks will give it before the appraisal is done. Some banks will give it after. There's different kind of standards. Some don't do commitment letters at all, which is really troublesome for the process. But the bottom line is there's a list of stuff that needs to be cured. When you look at that list, it may look like French or Spanish or some other language you don't speak. Call your loan officer, call your processor, and say, listen, I want to know what each one of these means. Because if you dig into it, you're going to know whether or not you're going to have problems. So one of them is going to say confirmation that child support is current. If you have child support. Well, guess what? If you know you're behind on child support, we're going to have a problem. We already know. Tell them now. Verification of employment day of. If you know that your old employer hates you and isn't going to tell anybody that you work there, you know this is a problem now. Let's get ahead of it. Let's figure out how to underwrite without it if we can. If not, then of course it could fall apart until the last day. The problem is that people don't get engaged and they don't sit there and pay attention to what's going on with their deal. So then it's a surprise when the day before closing, when we get the statement from child support, the whole deal blows up.
And this is, to me, what you just touched on is super important. And I think it plays into a lot of the parts of the process. Because if you're not paying attention to the deal, you're just focused on the house, or you're just focused on whatever it is, or again, not paying attention. But to me, one of the things that I liked about Matt specifically is that we were doing all these conversations like day one, actually day like -5, before we even did it.
It's phenomenal.
Hey, let's go through it. What are you making now? What do you have? W-2? Are you self-employed? And what is the status of all these other things that could blow up at the 11th hour? Let's get ahead of that now, not 10 days before close, 5 days before close, or worst of all, as you're getting the mortgage commitment. So mortgage commitment, when you get that part, and that's also in the contract. Correct.
Paragraph 3D tells you have how much time you get to get a mortgage.
To get a mortgage commitment. Now, as this process goes on, I think one of the important things to talk about is you're nearing this mortgage commitment date per the contract. Let's just call it, it's October, whatever it is now, it's the 13th. Let's just say on the 15th, you're nearing that date. You don't have a mortgage commitment yet. Everybody's working, but there's this black box, the underwriter, that you don't know.
Absolutely.
Anything. Now, what are your options, as you near that date, as the attorney, as the client?
So, as the attorney, we have two routes we could take. We could get ahead of the problem, which is a very good method, where we call the lender. We say, listen, give me a realistic date. Put it in an email. Let me forward this to the other side. Let them know that we're behind, but we're fine. Everything's okay. And that, to me, is the preferable method. Then there is the practical method. And the practical method is you sit there, you shut up, and you do absolutely nothing. And why do we do that? Because 99 times out of 100, nobody's paying attention. And
to the date.
To the date.
Okay.
So what happens is everyone knows when you're supposed to close, right? So people think that's written in blood, and we'll talk about TOE letters. I don't know if today or another day. I think we're running long. We're running long. But ultimately, everyone knows their closing date. Nobody remembers when the mortgage commitment date is. So like for my sellers, I send out weekly updates that say, hey, this is the day it's supposed to happen. Now, I don't claim to check every single one of my deals every day to check whether or not somebody's late. I have a calendar. My staff check on it. We make sure to stay on top of it. Have we missed a day and followed up the following day? Absolutely. Now, most firms don't have that level of involvement. Most clients, the sellers, aren't paying attention. Most realtors are concentrated on the closing date more so than the mortgage commitment date. And at the end of it, nobody checks from the seller side. I've had closing dates go by without a mortgage commitment, and nobody said a word from the other side. Now, I have that decision to make, right?
Correct.
As things are advancing, I call that lender. They're like, we're 3 weeks out. I'm not emailing anybody saying we're 3 weeks late. That's just bad practice. It's not good.
I see what you're saying. Interesting.
They tell me we need 2 extra days or we need 1 extra week. I'll let them know. We'll put it in an email. We'll send it to the other side. Hey, guys, everything's good. We're just running a little behind. Appraiser was late. Everything's cool. We're fine. That's not an issue.
Very interesting.
So there's a lot of choices to be made here. You could bury your head in the sand. At some point, you see lenders who are just failing to get the job done, and they won't even tell you why. So we have that. So we don't always get to choose our team, right?
Yeah.
So when people call me, we're working with XYZ Mortgage. I hope that's not a real mortgage company. It's a real mortgage company. I'm not talking about you guys. But we're working with XYZ Mortgage, and I call every single deal. The first thing I do.
Yeah.
Before I send out a rider, the client just retained me, I call the mortgage company.
Yeah.
I call the mortgage company, I call the realtor. I introduce myself if I don't know them, and I say, listen, here's what the contract says. Can we deliver on it? And if we can't, what do you need so I don't put us in a bad position?
Yeah.
That's the first thing I do.
To the best of their ability, to the best of their knowledge, because, again, so many things.
And now I can't wait a month for a response.
Yeah.
I leave messages. I buffer my time.
Yeah.
I won't conclude attorney review without talking to mortgage.
Yeah.
But sometimes I don't get a response for 3 days.
Yeah.
I don't get a response for 4 days. I can get out of a full attorney review. I explain to the client, listen, I don't know if your lender can make this timeline. They won't get on the phone with me. They must be talking to you. You check.
Yeah.
And they'll check and they'll say it's fine, and then we're okay.
Yeah.
But I've gone to the day of closing without hearing from a mortgage company at all.
Wow.
Nothing. Now, sometimes I don't care because they give me a mortgage commitment.
Yeah.
They are on top of it.
Yeah.
We're getting everything done. Everything's on time. Great. I don't need to talk to you. Fine. Have a nice day.
I like
But then I have the ones where it's 2 weeks later and they won't tell anyone what's going on. They won't tell the client what the issue is. They won't tell anyone what the issue is. Now I'm sitting there. I can't tell my client that everything's okay. It's not. We have a big problem. And what I do at that point is I get on the phone with one of my lenders who I trust.
Yeah.
I go, listen, I'm not moving deals from anybody. That's not my job. I need to know what's going on. Based on this profile, can you give me some idea of what the holdup is? And you'd be shocked how often the answer from people is, this deal can't be done.
Wow.
Where I'm like, hold on, this is the income. These are the liabilities. Here's this, here's that. Like I get the basic profile from the client, and I just call another lender, someone who I trust, someone who I know knows what they're doing. There are people in this industry who are experts and are masters at their craft, and I'm fortunate to work with a good number of them. And I call them. I go, listen, here's the situation. Never going to work. Can't be done. You have to either.
So they were sold.
They were sold a bag of goods. They were sold nonsense. They were given a pre-qual that's not worth the paper that it's written on. The deal can't work. And I don't find out about it until later, which is terrible.
That is terrible. Wow.
Because if I look, they're promising they can make something work. I've seen magic happen.
Yeah.
So understand that lenders are not all created equally.
Yeah.
And there are people who will work with their clients to make things happen that other people can't make happen. And those are not the lenders who aren't picking up the phone.
Right.
Those are the lenders who are on top of their game and letting people know what's going on.
Yep.
Then you have lenders who are working with some little lesser known investors. You've got your non-QMs out there. You've got the people who are working off of the standard market.
Yeah.
And they're also promising to be able to get things done. But the thing is, a lot of times they can't.
Wow.
And you find that out, when you get a time of the essence notice, when you get a notice, hey, if you don't get a mortgage commitment in 3 days, we're terminating the deal. Now we're in trouble.
Now, let's talk about that for a second. Let's talk about what happens. So in this instance, because this is a scary moment for everybody.
Absolutely.
The buyer, as you said, is not even aware of this stuff in some of these cases, right? So they're going along, chugging along, all happy, looking at furniture, looking at paint, thinking, oh man, I love that room. I'm going to do this.
Yeah, I'm going to make plans.
They're getting all excited, right? Hopefully they didn't have a house that they listed and are also under contract on that. But let's ignore that for a second. Now, you were talking about this situation now, and you're in this position where it's past the closing date. There's no shot.
Past the closing date,
Yeah, no shot that you are closing or getting a mortgage.
Yeah, we find out this mortgage isn't happening.
This is not happening. What, the scariest thing to a buyer in that instance is my deposit that we talked about before is gone, right? Or even beyond that.
Misnomer number 3. You just hit it.
Go.
So, quick pause, and then I want to hear the rest of the question. Your deposit's never gone.
Okay.
Deposits are not forfeited in New Jersey. What you're referring to is it's a giant misconception that happens chiefly, I believe, because of New York. I think it's New York's fault. There are two.
I like it. Blame them.
Yeah, we'll just blame it. Blame New Yorkers. It's all their fault. Two types of damages that exist in contract. There's liquidated damages and there's actual damages.
Okay.
Liquidated damages is something goes wrong, I'm walking away with X dollars.
Right.
That's how it works in New York. In New York, if you breach a contract, you do anything wrong, whatever money you gave, the seller's putting it in their pocket and they're relisting the property. That's it.
Wow.
Not how it works in New Jersey. New Jersey, I won't say every deal, let's say 95% of deals, there's no liquidated damages. Anything goes wrong, we're negotiating what happens with that deposit. Now, that's more important, and moreover, to understand is you're not limited to your deposit for damages. You can be on the hook for more.
Wow.
So, especially in this market shift we just had, buyers back out without any right, and we had, there's $5,000 sitting in an escrow account. They're like, fine, we'll lose $5,000. We don't care. Fine, we're willing to take it on the chin. But actually, you could be on the hook for the carrying costs of the seller until they sell the property, plus whatever the difference is between what you were going to buy it for and what the actual buyer buys it for.
Wow.
If the next buyer buys it for more, you're off the hook. You're clean. The next buyer buys it for $20,000 less. Seller can turn around and sue you for $20,000.
Wow. Let's pause here for a second. I think this is really, really important. So, liquidated
damages.
So, in this instance, let's just put some numbers on there. Let's just say you were buying a house for $800,000. That's what the contract was fine was for. Everything you went through.
Yes, sir.
You're trying to get a mortgage for, let's say, $600,000.
Okay.
You're going to put down
$7,500.
You're going to put down $200,000 for a down payment, and you're going to do a $600,000 mortgage on that home. With the mortgage,
right,
where they just was not happening. So that, to go back, so that is not something for. So if
that's not a basis to lose your deposit.
That is not a basis to lose
your
deposit, and is not a basis for the seller to go after you for.
As long as there's no bad faith. Correct.
Now,
so the general rule that most attorneys follow for mortgage back out is you cannot back out based on a mortgage contingency unless you have a denial letter.
I see.
Now, that denial letter is issued by most banks.
Right.
When they say, hey, this loan just doesn't work.
Yeah.
So that is a requirement for it. But basically, I get a denial letter anytime from the start of the deal until the day of scheduled closing, sometimes weeks afterwards.
Wow.
And my presentation of that denial letter is going to be a, hey, give me my deposit back.
Right.
Which is, it's great to be able to do it, but also just understand you're not getting the house. Right. And then all the seller has to do is say, hey, I'm alleging bad faith. I think you knew you couldn't get this house a month earlier. I think you applied for a loan that's different than what you promised me you were applying for.
Okay.
I think you didn't submit your documents, and that's why the loan failed. I think you refused to give your employer's phone number so they couldn't do a VOE.
Wow.
Now, this denial letter lets you know the reason for it. And there are boxes on there where it's like, hey, they just don't have enough assets. And it's like, well, they didn't have the money. Okay. Unless they waive their appraisal, but that's a different conversation. Fine.
Let's go to the third out for the buyer then. Title. So title is, as you said, that the title company is asserting in this case that the seller is the true owner, right?
Correct.
Has no liens.
They're insuring it. They're not asserting it.
Okay. And they're insuring the fact that is the true owner, that
no liens, judgments, or claims.
Judgments and claims are on them, and that they own it outright. And they can.
They don't have to own it outright because they can have a mortgage on it. So they don't have to. Like, there could be claims as long as those claims are going to be cleared at closing.
Okay. So that is very important too.
Yes.
Right. Because now when you're saying that they're insuring it is if, half a year from now, you get a lien or something like that, right? As you moved into the home, you get a letter. The insurance covers.
It's a little bit. So they only insure up until the day of closing. They don't insure things in the future. So they can't know if the seller stiffed their mechanic. Stiff their plumber, and then the plumber files a lien against the property thereafter. That's not something insurance can know about, right? They have no way to insure that.
Got it.
What they insure is that there's no active claims.
Got it.
So if there's future claims, and by the way, you can get that mechanic's lien off because you're not. They didn't file it in time while the owner was right. But the bottom line is they're insuring that nobody comes knocking on your door saying, "Hey, this house isn't yours; it's mine. Get the hell out."
Right.
That's the insurance. That's what you're getting. There is no mortgage that's owed on the house where someone else can foreclose on the house other than your mortgage. They are ensuring that there is no one else with a right to the house. That's the best way to think about it.
Okay. So give me just one surprise that you can have on a title aspect, just so the listeners can understand what a potential. So what is a?
I'm representing a seller. This was This is actually a very good friend's parents' deals.
Okay.
Like I say, I told you this before. Friends' deals are the worst. That's just everything goes wrong with them. Very good friend of mine. Very, very sweet family. Very nice. Finally decided they're selling their house one place and moving to another place. Sure. Got both contracts. They're contingent. If it doesn't work, you can back out of the other one. They really want this house, and they're really excited to buy it.
Yeah.
And they go to sell, and we get our title binder back, and there's 2 mortgages. Which isn't that strange.
Interesting.
A lot of people have 2 mortgages. Not a big deal. One of them smaller than the other. Could be 2 mortgage lines. There's enough equity in the house that this could stand.
Yeah.
So I send it over, and they go, well, no. We only have 1 mortgage on the house. And I go, well, no, there's 2 mortgages of record. 1 and 2. I can get to 2. I'm smart enough to do that.
I'm no CPA, but
I can get to 2. So you go, well, no. This other loan was paid off in a refi. I go, okay, where's your satisfaction? I didn't keep any of the paperwork. So mortgage loan comes on the record. When you pay it off, you get a satisfaction or a discharge of the mortgage.
Right.
They didn't have their satisfaction. We check the record. There's nothing on title. There's nothing at the county clerk's office.
Wow.
We sent new searchers. We couldn't find it. I personally combed through the county clerk's records. Nothing.
Wow.
I call the mortgage company. They're out of business.
Oh, wow.
I call who their rights were assigned to, because any FDIC mortgage company, when they go out of business, have to assign their rights to somebody else who still has to file those stats.
Wow.
They're out of business. We go to the third one. They're out of business. We find the fourth one. Finally, they no longer do mortgages.
Oh, my God.
They go, we have some archive department. It takes 6 months to get a response from.
Holy crap.
That's what I said.
Wow.
That's it. You got it.
Yeah,
Exactly.
yeah.
So now we're scrambling. We're really scared. It turned out that this particular family had done like 7 refis.
Oh, my God.
There was literally 7 loans. I had to do a color coded chart. It was a mess. And then lines of credit and whatever. Anyway,
Yeah.
but like they had done a series of them, and I go, well, who insured the last transaction? Because in order to do a refi, you still need title insurance. Title insurance insured it. There's this wonderful expression in the title industry. I love it.
Yeah.
Somebody is pregnant with the problem. Just
I heard that before.
a great expression.
Yeah.
But essentially, there are underwriters who actually issue the policies. These underwriters, whoever issued the previous policy, is already insuring against that satisfaction that was never filed. So
Right.
they should be willing to issue a new policy.
Yeah.
And we found the underwriter who did it. The title company was out of business, which
God.
like you're getting a picture for what a mess this whole situation
Well,
is.
yeah, I am. That
Because the
sounds
previous title
nuts.
company would have had their records. They must have had it, otherwise they wouldn't have insured it.
Right.
But they're gone. So
Wow.
we get in contact. We try and get an indemnification agreement going. They're rejecting the indemnification because when you get a refi, it's a loan-only policy. It's not an owner's policy.
Right.
They're saying they're only pregnant for $300,000, not $600,000. They don't want to increase their risk.
Wow.
It's a mess.
What a mess.
And what
That
ended up
sounds awful.
happening was I realized it was actually like the day, it turned out to be the day of the closing that we
Wow.
managed to solve the problem. We just kept kicking. We tried everything under the sun. And then finally I'm like, wait a second. They had 7 refis. Why did I only call 1 title company? Let me call every title company that insured
Those
after
refi,
that
yeah.
refi.
Yeah.
After the one that we need the stat for, someone must have it. And we called every single one of them, and one of them sent it to us. They had it on record, and it was recorded. It was in the county clerk's office, but it wasn't correctly indexed.
Oh, my God.
So this document's been sitting there, but no searcher
wild.
could find it because the county clerk misindexed it.
Oh.
And we managed to find it. We managed to get it confirmed. We managed to sell and buy on the same day.
Wow.
And it was a miracle. I mean, it was
a
incredible.
miracle.
And
Holy
it was
crap.
a ton of work. It was an incredibly unfortunate situation.
Stressful, I'm sure.
Extremely stressful. The buyers are like, are we getting a house? They're paying mortgage extension rates. The sellers ended up actually paying them for the extension rate because they
Wow.
felt it was their responsibility.
Wow.
It was incredible. I mean, it was a really, really messy situation that was cleaned up solely by somebody caring enough to hunt down every possible solution. You know, we hit 7 roadblocks along the way. Mortgage companies going out of business, title companies going out of business, misindexed at the county clerk's office. I mean, it was horrible.
Yeah.
But that is a cloud on title because if the buyer were to accept the house that way, they would be responsible for paying back that mortgage that's on the record.
Yeah.
And no
Right.
buyer wants to do that, and the lender
No.
won't let them, and it's insane to do it.
Yeah.
You couldn't possibly.
Yeah. Wow.
So there we are. That's an
wild.
example of a title issue.
That is quite a title issue. So yeah, very important to have that. So if you do not get the title, you can have an out as well, because in this instance,
there's an issue
if you could not figure it out,
Yes.
and then there was just no,
The buyer couldn't have bought the house.
the buyer couldn't
We'd
have
be
bought the
stuck.
house, so
And the
you'd
seller
be
couldn't sell the house, and the seller couldn't buy the new house, and the
That's
world
it.
would have fallen apart, and I managed to save the world. So I feel great.
So yeah, you're like a superhero.
Exactly.
So wow, okay, that's a lot to take in. That's really good stuff, though.
Another great example
Yeah.
we had recently. I won't talk about what town or
Yeah.
anything else.
Yep.
This is a part of title that not everybody bothers to opt for.
Yeah.
It's called a survey. So a
yes.
survey, you may know, is a drawing of the property.
Yes.
It shows you all of the easements on the property. It shows you where the major markers are. It shows you the outline of your land. Very important.
Very
To
important.
do. If you're buying a condo or an HOA, much less important to do,
Yeah,
and we can talk
right.
about that another time. But if you're buying a standalone house, I recommend everybody gets a survey.
Yeah.
100% of the time. They generally run between $750 and $1,250 for a standard 50 by 100 lot. If you're buying acres and acres, it will be way more expensive.
Right.
The most expensive one I've seen on a residential deal was $12,000.
Wow.
Which was
Okay,
crazy.
that sounds like a
but
massive
it was a irregularly formed, I think it was 13-acre
Whoa.
situation.
Okay. All right.
Where, it was like, it looked like a wavy pond where you had to run radiuses all over the place. It was crazy.
Okay. Sounds
So
intense.
it was an interesting deal.
Yes.
But, you get the survey. I recently got a survey back. We had a great surprise. We had no idea about this. There are two houses, one standing right next to the other.
Yeah.
It turns out they share a well.
Wow.
So they're 30 by 3, so 90 feet of the yard they actually have an easement on it, the next door neighbor, so that they could run a water pipe to the well point in order to get the water for their house.
And they're unrelated homes.
Unrelated homes.
Holy
it's not an
crap.
HOA. There's no agreement.
And they just
happens
share
to be
a well.
When the developer built both houses, they had done the subdivision. Instead of drilling two wells, which would have cost twice as much, they drilled a single well and ran it to both houses and gave an easement from one to the other. Now, that is a surprise.
That is a
everyone's aware
surprise.
of it. Now, is that a real issue for closing? Is anybody going to walk away from the deal? Probably not.
Yeah.
But if I change that 90 feet and make it 900 feet,
Yeah.
people feel a different way about it.
Yeah.
So that was one example. There's setback lines occasionally. So we recently had a giant issue. So in Manalapan, they require surveys to sell as part of the sales requirements.
The sales. Okay.
So it's called a ZCO, which just sounds like that's how Russians say CCO. It's ZCO. ZCO, yeah. So they actually require you to get a survey within 6 months of the sale to prove that everything has been permitted and prove that nothing is encroaching. So we have a purchase in Manalapan where the fence is 12 feet onto the neighbor's yard.
Oh, that's a lot.
There are pavers in the setback line that are not allowed to be there.
Setback line, just
Setback
real quick.
line, you are not allowed to build within that line.
Got it.
That's it. So
Okay,
30
cool.
feet into your yard, you're not allowed to build. Just
Okay.
hypothetically, something
Yeah,
like that, unless you get a variance. We had, it was incredible. It was a beautiful house, again, for a friend. So that's
Of
how it
course,
works.
naturally.
There was just a series of issues with it.
Yeah.
We had one where there was entire structure, an entire shed that was sitting in a setback line that had to be moved or had to be removed altogether.
Wow.
People thought they were getting a shed. They didn't. There was
Yeah.
no shed. They had to destroy the shed.
Wow.
Now,
Because it
once
was
you-
not in your property.
it was on the setback line
Yeah.
where the town doesn't allow you to build.
Right. Wow.
So there are these easements and there are these restrictions where, like, Manalapan, you're stuck in it. You have no choice.
Yeah.
And usually the buyers and sellers split the cost because it's required by the town. But when you go into, one town over, you go to Marlboro, there's no requirement to do it. It's your decision. And you may be purchasing a giant issue that you don't know about.
if
Because
somebody was to say,
absolutely.
yeah.
And then, like, on the craziest side of this, the craziest survey I've ever seen, we saw property lines. So these are drawings, right? So they generally draw a rectangle for the property line. The property line ran square through the center of the house. Just straight through. It turns out that when they made the legal description for the property, somebody blew it.
Oh.
And when they blew it, they actually built the house on 2 lots.
Oh, no.
And when I bought the one lot, so in New Jersey, you don't buy actually a house, you buy
By a lot.
You buy land and whatever's built on it.
Right.
So when when my client would have bought that lot, they would have bought half a house
Wow.
with an encroachment into the next yard.
Great.
We had to reset the legal descriptions. We had to do a series of conveyances in order to clean up this whole entire situation because the next house over, as it turned out, had half of our house on their land and half of the next house on their land. It was like everything was shifted down the whole block. Everybody blew it, and nobody had done a survey.
Wow.
And when nobody did a survey, nobody knew there was a problem. And all of a sudden, and these are new builds.
Yeah.
So this is a new house.
Wow.
This is like
Oh, man, it's
insane.
even worse. Yeah.
So the developer messed it up.
Yeah.
It was a mistake.
Wow.
And we found out about it. If we didn't find out about it, the guy who bought the house next door could have sued us for encroaching on his property, made us destroy our entire house.
Wow. Yeah.
And how much did we pay for the survey? $750.
Wow. That's
So
a really
that-
good
that's
point. Even
why
if you,
surveys are
I mean,
important.
to destroy your entire house, I feel like I would pay like $40,000.
Well,
Yeah.
that's a very expensive insurance policy.
it is.
But to check and to do your due diligence
Yes.
is definitely part of your due diligence. And encroachments, let's make it a little bit less crazy. Let's just say I built a shed in my backyard,
Yeah.
and oops, half of it's sitting on my neighbor's yard. Let's get rid of the house. Let's put a shed.
Sure.
Right? Well, that neighbor can sue you at any time.
Yeah.
And you're running that risk as the new buyer because now it's your shed that's on their land as opposed to the previous guy who built it.
Right. And clearly destroying a shed.
Well, less scary. You know what? It depends on the shed.
Yeah, true.
It
true.
depends. Sometimes it's an outside garage. So sometimes
True.
you have like a disconnected garage
Or
where
like a pool house.
or pool house.
Or
Yeah,
whatever it is.
there's a lot
That's
of
a good
different things
point.
that can happen.
That's a good
And
point.
it can be tremendously expensive.
True. That's great consideration. So, yeah.
So that's another
Survey,
title issue.
yeah. Surveys, which is part of the title, to kind of summarize those things. Inspections and mortgage commitments are outs that you can
For the
have
buyer.
for the buyer.
Yes, sir.
That would return back the earnest money deposit, right? to them.
Assuming that things go the right way. So
Yeah.
if you get a mortgage denial, it's not your fault. You didn't have
Yes.
any bad faith. You get your deposit back.
Yes.
The inspection request, you make requests you're allowed to make. The other side says no.
No,
You have
you
a
get
back
it.
out right.
Correct.
There's a title defect that cannot be cured within a reasonable period of time. You get your deposit back.
Got it. All those things play into it. Assuming it's all good, or and assuming you're getting near the end of the road, so to speak, the clear to close, the closing date.
Yes.
Now, I do want to talk about the TOE, or what's known as the time of the essence letter, because I've experienced that. I've heard that term, and I've almost was called on it basically in my closing. So, my understanding, and correct me if I'm wrong, is time of the essence letter is issued if you are beyond the closing date, or on the closing date.
So
Or-
here is
yeah.
the situation with TOE letters.
Yeah.
And there's a lot of confusion on this subject. I'm not going to call this a misnomer
Yeah.
because this isn't confusion from like the industry.
Right.
This is just confusion because it's complicated.
Okay.
So TOE letters can only be issued in the following circumstances. One of the sides is ready, willing, and able to close. They've done everything that they're supposed to do. They're just sitting and waiting for the closing.
Okay.
The time for the closing has elapsed. So whatever the closing date you set has elapsed.
Okay.
And you are saying, hey, if you do not close by X point, which is by law 10 calendar days, you can agree to whatever you want in the contract. So I
Yeah,
like to push
okay.
for 10 business days
10
for my
business,
buyers. There can be an agreement between the parties, and the law actually says that it has to be reasonable anyway. So
Right.
if something crazy happens, obviously all of this gets a little bit shifted.
Sure.
But let's just say generally 10 calendar days is the
Okay.
rule. I can say, hey, if you don't close in 10 calendar days, I'm going to relist this property and sell it to somebody else.
Okay.
I'm not going to release your deposit until we find an agreement as to what's going on.
Okay.
So that deposit's going to be sitting in escrow, and I'm going to go remarket it and sell it to somebody else. That's the situation.
Got it.
Generally, they can't actually sell to somebody else while there's something called a notice of settlement on file. Notice of settlement is filed by a title company, letting someone know that we're trying to buy the house.
Right.
And generally, in order to get that notice of settlement lifted, you will negotiate with the other side to figure out what's going to happen with the deposit.
Got it.
You're not going to run up damages, whatever. We'll talk about it.
Yeah.
Let's not get,
We won't
let's not
get
get in the
too
weeds.
far ahead.
We won't
Yes.
get too deep in the woods. But in short, it's saying, hey, closing date has passed. You have 10 days to close. If you don't, I'm going to mitigate my damages by selling to somebody else.
Got it.
If you're the seller. If you're the buyer and the seller won't do it, you're saying, hey, you need to close on this deal. If you don't, I'm going to sue you.
Right. Now, can the buyer have a time of essence?
Absolutely.
Okay, so both sides can
Both
call
sides
time-
have it.
time
They
of
just
the
have to
essence.
be ready, willing, and able to close on that date
Got
in
it.
order to issue the timeline.
Okay. So if they're not getting their clear to close, for example,
You're not getting that clear to close.
is that willing, ready, and able?
No.
Okay.
If you don't have a clear to close, how can you tell the other side you must close immediately? That's
Correct.
insane. Now, the seller can
Yeah.
be ready, willing, and able to close. And they're saying, listen,
Yeah.
I don't care that you haven't gotten your clear to close. You've got 10 days to get it, or I'm going to go sell this house to somebody else.
Right. Interesting.
And that's possible. And that happens a lot.
Yeah.
Even
though it's out of the hands and out of the control.
it's
of
not
the
it's not a
buyer.
buyer's fault per se.
Interesting.
Though usually when you get into those situations, you find that buyers were a little late in submitting paperwork.
Right,
People were
right.
dragging their feet. Maybe the processor got a little bit tired. Somebody was
Yeah.
on vacation. Things happen in a deal, but that's not the
Interesting.
buyer's fault. But it's
Yeah.
the lender's fault. But when it's the lender's fault, it's the buyer's fault. That's their side of
Correct.
the deal.
Interesting. Wow. All right. Well, look, as we try to wrap up here, we're running a little bit over time, but this has been just so phenomenal that I think it's value packed in and of itself and super important. But why don't you, tell the listeners, the viewers, how do they choose a real estate attorney? You yourself clearly are extremely knowledgeable, well versed in all of this. You're able to explain all the stuff in really good, understandable terms. But somebody out there, maybe even in another state, whatever it is, how do they pick an attorney to work with on a real estate transaction?
So first of all, thank you. I appreciate the compliments.
Yes.
I truly do. If we're talking about any other state, I can't speak to that.
Sure.
So there are different
Okay.
processes. A lot of states don't use attorneys at all.
True.
But in New Jersey and New York, when you're trying to pick an attorney, the keys are very simple. If you call the company, the firm,
Yeah.
and you ask to speak with an attorney because you have a closing coming up,
Yeah.
you like to speak to them, they put you through to a paralegal. You have a good sense of who you're going to speak to throughout the deal. Nothing wrong with that whatsoever. I have a wonderful paralegal who works for me. She's very intelligent, very competent. Our firm chooses to have direct-to-client communication between the attorneys. Not every firm does. But step one is, who are you going to talk to?
Okay.
Know who you're speaking to for the transaction. Who am I calling? Am I calling the main line to dial an extension to leave a message to hopefully get a call back? Or am I getting someone's cell phone number?
Interesting, because that's going to give you the vibe.
Absolutely. You're going to get a sense for who you're dealing with.
Got it. Interesting.
If someone says, hey, this is going to be your main point of contact, and it doesn't say ESQ at the end of the name, you know who you're talking to, and that's fine. There's nothing wrong with that whatsoever. There are paralegals in this industry who know more than attorneys, and I'm not in any way ragging on them because they're great paralegals, but you should know who you're dealing with. You should know what you're paying for. If you're paying to talk to a paralegal the whole time, that should be within the price. That should be understood. Which leads to number two, the price. You should know what you're paying for. There is a law firm, I believe the gentleman's name is, well, let me not pitch other law firms. If you look him up, it's not hard to find. He does closings for $395.
Wow. Okay, that's low.
That's not a high price at all.
Yep.
It's extremely affordable, which is great. And there are clients who should take advantage of that. But those clients will never speak to that guy. They are going to speak to probably not a paralegal, but rather a secretary, because the paralegals are too busy. It's crazy. I mean, I've had dealings with that firm, and I wish them nothing but the best, and I wish them success. I hope they make a lot of money. But you should know what you're signing up for if you sign up with a firm like that.
And you get what you paid for.
Sometimes. It's interesting. So I've seen people who have incredibly low prices who provide great service. They tend to not be volume. So I've seen some attorneys who are wrapping up their practice. They're going to do a couple of closings. They're incredibly intelligent. They talk directly to their client. They charge almost nothing for their services. They're great. But then you're dealing with other issues that come in. So one of the things that's very important to my firm that I strongly recommend everybody ask about, what are you doing to secure my data? We live in a time of wire fraud. We live in a time of identity theft. We live in a time where we must secure our data. And that is the number one question, number 5 question, I would probably ask if I was hiring an attorney. I want to know that my social security number is not flying around in emails. I want to know that my social is protected behind encrypted software, that the paralegal working at the firm should not be readily accessing that data unless it's permissioned. Or, you know what? I take that back. Paralegals should have as much access as attorneys do. I take that back. I want to make sure that the secretaries don't have access to it. I want to make sure if someone just hacks through your firewall, generally real estate's practiced by smaller practitioners. You don't see 50 lawyer, 100 lawyer law firms too often practicing in this space. So most likely you have a rinky-dink firewall. And is that all that's standing between my data and a hacker? Because if it is, I want to know that. I want to know what's being done. So like our firm functions, every single client gets an encrypted client server. There is hashing for SSNs in compliance with the European standards. The US doesn't currently have any. We have, so our client portal system has actually hired Google to try to hack them to see if they can get data, and they can't. So, you know, we work with security experts as far as that field goes. And like, that's something that's very important to me because I don't ever want that to happen. At the same time, you have the best systems in the world. Do you have internal protocols in place? So all of my employees laugh at me, or all of the attorneys that I work with and realtors and everyone, they laugh at me. If I walk away from my computer, I lock my computer.
Smart.
I will never keep a computer open. I have mandates, and I have set all of the settings for every single person who works for me so that it will time out and lock, and every one of them knows when they go through their training, I hound on them. You do not walk away from your computer with it unlocked. It's too easy to lose data. It's too much of an issue. And we sit there and we try to enact as many protocols as we can. We're constantly learning. We're constantly trying to better ourselves. And that's, to me, the biggest focus of 2022 is fighting wire fraud and fighting identity theft. And that's a question I would be asking. Past that, I just want to know the person who I'm talking to, do I connect with them well?
That's a good point.
I've had people who called me, the first things out of their mouth, how much is it your service? I tell them, like, listen, let me tell you a little bit about my firm.
Yeah.
Let me tell you a little bit about the process. Let me give you some value, and then
like
I'll tell you my price. Because I want to know who you are. I want to know that I want to work with you.
Yeah.
Because if you're going to
It works
sit there,
both ways.
that first phone call with how much do you cost?
Yeah.
My knee jerk is I don't want to work with this person.
Yeah. Yep.
I
I
wanna-
have the same reaction with my clients too.
100%. I want to know who I'm dealing with. I want to give you something for free and then understand who you are during that conversation
Yeah.
so that I can decide what price I'm going to be quoting.
True.
And I can decide whether or not I want you as a client at all, because I've had conversations that, you know what, after thinking about it, I just checked my schedule. We're really packed. I don't think this is going to work out.
Yeah.
Or-
And it's for the best for everyone.
Absolutely. Or you could do what a lot of businesses do, which is you just double the price and see if they'll pay it, and they never will.
Yeah.
Which, that's a conversation also. But get a sense for who you're talking to. Get a sense for whether or not they specialize in the field. And that's the most important thing.
Yes.
Because you do have attorneys who do not specialize in real estate sitting and doing real estate law.
Yeah, it's very
and
risky.
it creates a lot of problems, not because they're not great lawyers. They're probably phenomenal lawyers, but that doesn't mean they know what they're doing in this field.
Yeah.
From my time in landlord-tenant law, occasionally you would see a guy come in a $5,000 suit.
Yeah.
The average cost of a suit in landlord-tenant court is $250 in New York because you wear them
What I
all
know.
day and you just go through them like they're hotcakes.
Yeah.
So you see a guy come in a $5,000 suit. He writes his motions in landlord-tenant court in New York
Yeah.
tend to be 3-4 pages long. He writes a 50-page motion. He has a memorandum of law that's this thick that he's handing out to everybody, and the judge looks at it and he throws it to the side and goes, "So what's your argument?" And the guy's never ready for it because he's used to arguing in a different form.
Yeah.
He's a great lawyer. He gets paid
Interesting.
way more than the average L&T attorney. He's extremely intelligent, phenomenal attorney who's just in the wrong courthouse and doesn't have the relevant experience in that
Right.
area of law to be effective for his
Interesting.
client. And that is the same thing in residential real estate. You need someone who's sitting there
Yeah.
and grinding through this every day. If you hear your lawyer is in court more than once during your transaction, you have a pretty good idea that you're not working
Yeah.
with somebody who's just doing transactional law.
That's a really good point.
And that's going to be an indicator. That doesn't mean they're not great at their job. It doesn't mean they
Yeah.
won't do a good job on your closing. But for me, I structure my firm around this. So like this is a very
Yeah.
passion point for me. I want someone who this is what they're doing. I have my person who's sitting there and just doing closings all day long. They're an expert in it, and they're going to take care of me.
Yep.
So the question should be, how much do you cost? It's important to know.
Yep.
Who am I going to speak to?
Yep.
What are you doing to secure my data?
Yep.
Can I speak to the person and find out if I gel with them?
Yeah.
Do you practice other areas of law? The particular individual on my case.
Yep.
Those are my 5 questions.
That's
if I'm
perfect.
going to be interviewing an attorney to do my closing.
That's great. Those are really, really good tips, really good points. Really, it was an incredible honor and to have you on the show. You know, it really just the value provided today was unreal to me. Clearly naming all the misnomers that
Well, there's a lot
that
in
are
this
so
industry.
common.
There's a lot in this industry.
And you know, I really hope that it provided a ton of value to the listeners. And Andrew, why don't you wrap this up with just how do people get in touch with you? I know you said it at the beginning. Let's say it again. And you know, how do you get in touch with you?
Absolutely. Anybody who wants to reach me, my cell phone number is 908-217-7022. My email address is andrew@BershLaw.com, BershLaw.com. Our website's www.BershLaw.com, BershLaw.com. There's a contact us form there. You can email us. You can call us. You can send us a pigeon if you want. And we'll do our best to respond in time.
You got a pigeon
Yeah,
holder.
if I get a pigeon in, I'm going to be very grateful. I haven't been
would
delivered
be very
anything by
cool.
pigeon yet, so that'd be great. But anything we could do, please feel free to reach out. We are happy to speak with everybody, and if we can't help you, we will find you the right person who can.
That's amazing. Amazing. Thank you so much again for being on the show. It was a pleasure.
Thank you so much for having me. I
Yep.
really appreciate it.